So, Daniel, 3 weeks ago, I think, about really important Supreme Court case, Guest and Guest. I think we've been waiting for this for a long time.
Yeah.
This is going to be the case on proprietary estoppel. I think law students are going to be reading this for the next at least 10, 20 years, maybe longer. It's going to be one of these ones that are going to go down in history, isn't it?
It depends how long it's going to take to go back up, I guess. But yes, you're right. It's a very, very important case. It's probably worth briefly setting out the factual background.
Let's do that.
So as with all of these types of cases, or many of them at least, it concerns a family farm. You have a son who, relying on one of these one day son, all this will be yours type promises, forgoes various educational opportunities and ends up spending most of his life working for relatively low wages on the family farm in the expectation that one day it would all be his. Obviously, from the fact it ends up in court, things soured at some point. I think the son moved off the farm, parents threatened to write him out of the will, and it ends up in proceedings where the son's claiming a remedy by way of proprietary estoppel. So there are a few complicating factors arising from the fact there were some other children and some of the property had been sold, but basically it's as close as you can get at its core to a kind of proprietary estoppel type exam question almost.
Yes. So, basics of proprietary estoppel then. A promise doesn't have to be intended to be legally binding, doesn't have to be sufficiently certain as would be required to amount to a contractual promise, which by the promisor, relied on by the promisee, and then some detriment suffered by the promisee in circumstances in which it's unconscionable for the promisor to go back on the promise, and then equity intervenes and grants a remedy. And if you look up the relevant page of Snell's Equity, it says the minimum equity to do justice. I don't know. Can't be very good. So the question is, minimum equity to do justice, that's what we're told. What is that? And then there's huge debate going on about what the court should do. Should it simply compensate the promisee for the loss that it suffered in reliance on the promise? Or on the other hand, should it in effect enforce the promise? Should it get its expectation loss, therefore, or should it get its reliance loss? And that's the big debate, which is resolved by this case, is it not?
It is. Well, we have a split decision. Lord Briggs speaking for the majority. It's a 3-2 split, and Lord Briggs for the majority says this is expectation-based. He says the court needs to firmly reject the view that the purpose of the remedy is to compensate the promisee for the detriment. He says, quite strikingly, that's wrong in principle and wrong in its results. He says this is an equitable remedy. It's not there to compensate the promisee for financial loss. It's there to fasten upon the unconscionable conduct. And so he says we should have a 2-stage test, and this will now be the law because this is the majority judgment. First of all, you work out if there has been unconscionability, and the factors you've just given from Lord Walker in Cobbing Yeoman's Row are still the relevant ones. And then the second stage is to work out what is the correct remedy to purge that unconscionability. And he says the starting assumption, not presumption, but the starting assumption is that you enforce the promise in specie, but it's open to the promise breaker to persuade the court that that would be out of all proportion and that some lesser remedy should be substituted. And we can talk a little bit about what that looks like practically, but do you want to say something on Lord Leggett first?
Well, yes, but just to finish off on Lord Briggs. So it's I think it's Lady Arden and Lady Rose agreeing with Lord Briggs. They're the majority, and his starting point is that the whole aim of proprietary estoppel is to remedy the unconscionability of the promisor going back on his promise.
Precisely.
And that's why you get to the primary remedy being the expectation loss, unless that is out of all proportion to the detriment.
Although interestingly not disproportionate, and we can maybe come on to that in a moment. Whatever that means.
I'm not sure I know the difference, but there we are. But yeah, I think, to my mind, a really interesting, very powerful dissent by Lord Leggett, with whom Lord Stevens agreed, saying, no, the aim is not to remedy the unconscionability of the promisor repudiating the promise. Rather, it's to protect the detrimental reliance, or rather to give a remedy for the detrimental reliance suffered by the promisee if the promisor reneges on the promise. So Lord Leggett would say the starting point, if you like, is not the expectation loss, it's not fulfilling the promise, but rather the starting point is looking at what detriment is suffered by the promisee here. But we know that wasn't the majority. So going forward, therefore, the majority view in practice is going to mean what, do you think?
Well, I think, first of all, it's perhaps interesting. There's a kind of higher order question in the debate about the nature of almost equitable remedies. There's been some concern for some time about the sort of so-called financialisation of equitable remedies, cases like Coventry and Lawrence. And here we sort of see Lord Briggs fighting back a little bit and trying to carve out equity's corner. I think the first interesting point is this point about disproportionality. So Lord Briggs makes the point that the fact that something appears to be disproportionate doesn't mean that the remedy will be unconscionable. Because of the way that property prices have escalated over the last few decades, then quite frequently there will be a significant delta between the detriment suffered and the remedy that's being granted by way of
I mean, I think the difficulty I'm having with Lord Briggs is with applying Lord Briggs's view. I think it's very, very clear. You start with what do you need to do to fulfil the promise that the promisor has reneged on. And then you look at the detriment suffered by the promisee and you say, is one out of all proportion to the other? He gives an example of a Fabergé watch or something that someone's been promised, not realising it's been costing worth millions of pounds. And then that would be out of all proportion to the detriment suffered by the person who agreed to work for the elderly widow for the rest of her life or something like that. But how do you work out, one, when it is out of all proportion? And if I can just finish.
No, go for it.
The second point is, once you've worked that out, what do you then do? Because he's very clear that if the expectation loss is out of all proportion to the detrimental reliance, that doesn't mean you go back and just compensate for the detriment.
It's not entirely clear where the tipping point is, and both judgments sort of deal with this. Lord Legate says, well, are we back to the days of equity being as long as the Chancellor's foot? Lord Briggs' response to that is to say, well, actually, quite often these are cases involve fairly unquantifiable forms of harm. He talks about the gut-wrenching emotional harm of realising that a family member's been duping you for many years or has suddenly reneged on a promise that you based your entire life around.
Yeah.
And so I think he's quite candid about the fact there are going to be some fairly complex and difficult valuation exercises almost. He does also make the point that, in fact, enforcing the promise in specie perhaps gives you a little more certainty than going straight to a financial remedy. One quite interesting point, I think it's paragraph 104, is he says there may well be cases, and this is one, where in fact there will be two remedies that would do sort of equal justice on the facts, and in fact the promise breaker could be put to their election by the court and have to pick between those two remedies. So you may even end up in cases where the court is kind of offering a choice to the promise breaker.
I want to ask you something, which is this. There's a really interesting bit, I think, in Lord Legate's judgment, and which kind of stopped me in my tracks and really underpins Lord Legate's view, and I wondered what you thought about it, which was this. So Lord Legate says, look, we have a particular area where if you make a promise, then you're held to that promise. If there's breach of it, you get your expectation loss, right? And that's the law of contract. And it requires two things. It requires a promise that is intended to be legally binding and which is sufficiently certain. Why, he says, in a case where the promise is not intended to be legally binding and is not sufficiently certain to be enforced, which can nevertheless give rise to proprietary estoppel, and where there's detrimental reliance, should one be giving the expectation loss? In effect, you're extending the law of contract and enforcing promises where the requirements of the law of contract have not been met. And I found that a very, very powerful point.
Well, I think there's a response to it, which is the whole point of equity is to fashion a remedy in circumstances where there is a gap in the common law that result in injustice. There may well be cases, Cobb and Yeoman's Row would be an example, where actually it's fair to say these are commercial parties who deliberately chose not to enter into a contract, and allowing proprietary estoppel to sweep in would be wrong. That was a result in Cobb, although there was an unjust enrichment remedy. In a domestic setting like this, where one would not expect the contract to even necessarily be contemplated, let alone entered into, actually leaving the person who has suffered significant detriment on the basis of their expectation without a remedy would be wrong. And the fact that the common law has blinded itself to non-financial remedies doesn't mean that equity's more fair and flexible approach should be disregarded.
And do we think, other thought that's just occurred to me is, I wonder whether Lord Legate's dissent will have something to say about the question of whether the law of estoppel is going to be applied more widely in cases where it's treated as a cause of action rather than just as a defence because of this?
Well, it's already treated as a cause of action. Of course, this is an exception to the rule that estoppel is normally a shield and not a sword.
Yeah.
I think Lord Leggett's dissent is very powerful. I'm sure there'll be attempts to rely on it, but I'm conscious
I want to give, we're short of time, but I want to just one final point is this. Really interested in the debate between Lord Briggs on the one hand saying broad discretion for judges here, ideas of unconscionability and ideas of proportionality, and on the other hand Lord Leggett saying, look, we should get away from judicial discretion, save where it's really necessary, and even then we need to set out quite clearly what the purpose is of giving the judge that discretion. And it seems to me, even though he's in the minority, that's going to be very influential going forward.
As I say, I think that rhymes to an extent with the approach and commentary in Lawrence, and I think across equitable remedies we're going through a bit of a sort of hinge time where there's quite a lot of change going on, so watch this space. But I think on proprietary estoppel, this is the final word for now. So
let's leave it at that, but this hugely important case, we're all going to be, law students are going to be reading it for the next 50 years, we're all going to be reading it, and I think lots of work for lawyers, so good news for everyone here.
And an update of Snell.
Absolutely, yeah.